Welcome to VLGA Connect. My name is Catherine Arndt and I'm the Chief of the VLGA Connect studio. I hope you enjoy today's Connect episode brought to you by the VLGA, the national broadcaster on all things local government.
Good morning and welcome to a special VLGA Connect governance update presented to you thanks to our friends at Hunt & Hunt Lawyers. Today's going to be rather different. Rather than roaming around a number of topics, we're going to dive deeply into one, workplace investigations, and we've got someone here who is rather expert at the topic. And a big welcome to Sarah Rey, founding partner at Justitia Lawyers.
Hi Steve, lovely to be here.
Great to have you here, Sarah. And as I mentioned, we're going to talk about this one topic of workplace investigations, which I think is not an area that people in management, in local government or councillors with an oversight role want to spend more time on than they have to, but it's important that we get it right. And maybe we could start by giving you a bit of an introduction and a bit of background about your role and the role of Justitia in this space.
Thank you. So yes, as you mentioned, I did co-found Justitia 17 years ago and was very fortunate to start working in the local government space from those earliest days. And that came about because one of my very long-standing clients got her first job in a people and culture role at a metro council, and thus the journey began. And I think at that time we sort of established ourselves more in the employment law space, and then in more recent years have been working more in the governance space as well, and that's involved helping councils and councillors with their codes of conduct, team building and conflict resolution. And we certainly absolutely love working in local government. It's so diverse, lots of work types. From an employment lawyer's perspective, that's fascinating. But who gets to work with an organisation that has over 100 services that they deliver? So that's incredible. So connected to both the employment law work and the governance work, we also do investigations and help councils handle and manage complaints. And so we might be wearing one of two hats. So it might be the advisory hat, where we're providing the legal advice and helping determine what to do with a set of circumstances that are challenging and need to be investigated further. Or we might be wearing a hat where we're actually conducting the investigation, and in those circumstances we're either retained directly by the council or we are retained by a law firm. So there'll be other law firms obviously that do this sort of work, and there are also non-law firms who do investigation work as well. So I have been practicing as an investigator for 30 years and conduct training in the space, and have seen it evolve over that long period of time into a fairly sophisticated and big industry, really, as probably many of your listeners will be familiar with the fact that there's a lot of work in this space, and I know we're going to talk about how to set these things up for success.
Yeah, we will. And there's probably one other bit of context, Sarah, and that's maybe to talk about your role and approach to, I guess, conflict resolution or relationship management, because certainly that's one of the reasons where at the VLGA I really love working with Justitia, is that approach that you bring to your work.
Thank you. Yes, so that is a very strong value and theme of our work, and it emanates a little bit out of the investigation work, because we see often that there's a knee-jerk reaction to go down the investigation and formal route to deal with problems, to deal with conflict at work, and particularly where there are interpersonal relationship issues or low-level conflict issues, there are other options out there other than investigating. And so one step is to help clients explore what those other options might be and entering a dialogue with the parties to see if that's maybe a course of action that they might want to pursue first. There's always an investigation route as a secondary course. But that is also, as you know, building up people's capacity to have these conversations that are sometimes more difficult and arising out of the disputes and the conflict between people. So yes, that is a passion piece for me personally, to help people look at that area much more than they typically do.
Yeah. Now I'll need your insight here, Sarah, because I'm a bit worried that I'm about to open Pandora's box in terms of complexity, but I just wonder if we can, on that point you're raising, come back to when you're talking about investigations, what are some of the common dynamics in the lead up to Justitia being called in?
So when we're called in and hear what all the issues are and competing interests, certainly I think it's really important to pause and to work closely with the client to understand what all those moving parts are before you then make a decision to go down a particular course of action. Things that you might take into account obviously are where there are clear breaches of codes or policies that need to be looked into, where disciplinary action might be a consequence. As I've already mentioned, if it's more relationship conflict, then we try to urge them down that route first, and we help coach them to have those conversations to entice people into that sort of a process. If it goes down the investigation route, then the types of things that they'll need to think about are, well, who's going to oversee that process internally, and making sure that there's no conflicts and that the individual decision maker, for example, is not involved in the investigation, and that people who have been accused of wrongdoing or had bullying allegations made against them, which might even be the CEO who's had the allegations brought against them, to make sure that they're completely taken out of the process. So then you've got to work out who's involved in the process internally and independently sort of helping make decisions. So that's the first part. The second part is if we're involved as the law firm, for example, then is there going to be an investigation? Who's going to help conduct that investigation? Are they available? Can they do it quickly? What's the cost going to be? Are there reputational issues? Is the gravitas of the investigator going to be important or less important? So helping counsels make those decisions, or this is sort of information and issues that they need to be thinking about as they're setting up the investigation. What are the allegations? Can they be crafted now, or does more evidence need to be gathered before they can be finalised? And I know the other part of this conversation as well is we're not just talking about matters that might be investigated in an employment setting, so employee issues and employees of the council, but also councillor issues and whether they might be investigated by the council. And the main reason and area where we see those sort of investigations occur is from a work health and safety perspective. And so, as we know, the CEO has responsibility for ensuring a safe workplace, and sometimes things happen that might involve counsellors. And the purpose of the investigation ultimately is to gather information for the organisation to make decisions, make good decisions. So if the CEO understands there's a set of facts where something's happened, they have a right and a duty to investigate those matters in order to then form their views about what they need to do next to create a safe workplace. So that may pull in counsellors into that sort of process. Now, there are some councils we know that do that sort of have that response and undertake that process, but it can get a little bit contested where it's never been discussed before, because as we know, counsellors cannot be made to participate in that sort of a process, and ultimately it is up to them as to whether they want to be involved. But what we tend to recommend is that conversation is had between the executive and the council group, and ideally that it might even be flagged in a code of conduct, that where there are work health and safety concerns, that the CEO can initiate an investigation.
So just to be clear on that one, Sarah, you're saying that sometimes, particularly where it's a counsellor, the conduct of the investigation might come as a bit of a surprise.
The fact that there might be an investigation into their conduct,
yeah,
that the CEO, for example, wishes to run, that certainly will often be the case because it just hasn't been discussed. Often the scenario, the disaster hasn't been anticipated until it happens. And then everyone's scrambling, and we know of some high profile cases, where some disastrous things have happened that have been, initiated by a counsellor, and it may or may not have involved council officers, and it's certainly clear cut when it does involve council officers, because the CEO then has to decide, well, how do I protect my council officers from this happening again, or from the harm that might eventuate if it is allowed to continue. So the CEO wants to understand what's going on in order to then put measures in place, ultimately. Essentially a bit of a risk assessment as well, what's happened, what do we need to do now to ensure this doesn't happen again? And ideally, you want the counsellors to have the buy-in to participate and to trust the process as well. And I think the trust issue is a really big piece, as you and I know. And part of trust is really good communication. So explaining, this is what we're doing, this is why we're doing it. We may end up putting allegations to people, but we will tell you about those matters. We will not ambush you. You will hear about what the allegations are, and then a time will be made to talk to you about what those concerns or allegations are that we want to understand better. So, that communication piece is really critical.
Can we, just a quick check on the frame, Sarah, and then we'll move into the steps. So what you're saying is, in terms of Justitia, there might be a range of roles that you perform, from being the legal advisor to doing the investigation yourself to oversighting a third party to do an investigation.
Yeah, that's correct. And being very clear about which hat you're wearing.
Yes. And these matters might be anything from a personal disagreement in the workplace through to bullying, through to some sort of misconduct, through to higher level
fraud, expense claim issues, corruption. Yeah.
I presume, as with all investigations, that one of the issues is that sometimes you don't know where the investigation's going until you actually start.
That's correct. That's correct. So certainly one of the bits of advice is to sit down and think fairly carefully around what the purpose of the investigation is. And after you've assessed your complaint or your set of issues, the second step is really scoping it carefully. So that's to ensure that it doesn't go off the rails, doesn't grow bigger than Ben-Hur, doesn't blow the budget. And if there are other matters that come to light that might expand it, then doing that with, very with intent and looking at how that then needs to be examined further.
In clear eyes, is there anything else in that sense in terms of that early planning that really needs to be top of mind for executives involved in that?
Well, all of those things that we've just covered. And then I think ultimately the choice of the investigator is just a big important decision, just making sure that they're the right person for the task at hand. And there's lots of choice, as there should be, and there might be areas where you need special expertise, like that might involve a child safe issue, for example. So then you want an investigator that has experience in that area. If it's an accounting issue, then you need to work out, do you need to bring in an accounting person? Is it a matter involving, First Nations people? So do you need someone who's had cultural awareness training, or do you need a contact officer with that background to help facilitate the process? So all those things should be thought about at the beginning to ensure that it does the job. Yeah.
You've gone to some nuance there. For many councils in a rate capping environment, there is just a question around budget and value.
Yes.
How do those sort of decisions land?
Well, that's in talking about the who's doing the investigating, finding out what their costs are, and understanding how the steps that they're going to take and how they've estimated what their costs are going to be. Because even if someone says to you, oh, look, I've got a low hourly rate, well, if they're not very efficient in the work that they do, then you land in the same place. So you do want to understand, and typically investigators should provide some detail on what's the process they intend to follow and what the costing is going to be for that. Sarah,
sometimes these things arise in a flurry where people are thinking quickly.
Yes.
And I always get sort of caught up in this kind of tension around how do you plan for the outcome without prejudging what the outcome's going to be? What's the sort of thinking you would recommend there?
Well, both for the legal team and for the investigation people, just ensuring that people are available when the crisis arises, because it usually the most intense period is from the moment that it arises. And it's about thinking about all those many issues and being comfortable about the course of action that's being taken, but also bearing in mind that everyone's quite stressed as well while it's going on. And I think it's really important that the advisors are really good at managing and helping people manage their own stress as well. And that can be, I think, done in a really supportive way, depending on, how you work and how you work with your legal advisors or your investigator or whatever. You need a lot of calm, and you need good, clear and careful decision making.
So we've done the scoping. We've got got an idea of who should do the investigation. What are the following steps?
Sometimes the investigator will have created an investigation plan, and they will usually provide that to the client or the law firm. And the purpose of that is sort of identifying where we're going to get our evidence from. Is it CCTV footage? Is it computer related data? Swipe card analysis. Most evidence comes from interviews with witnesses. Mostly they're done face to face, but that doesn't always have to be the case. There are questions about whether you record, do you work off transcripts, do you take statements, do you take notes, how do you work with the witnesses? The investigator's job is to gather all of that evidence, analyse that evidence. With regard to witnesses, they're making credibility assessments as well as to whose version of events they believe over somebody else's version. That's what their job is, to make a call on that, no sitting on the fence, ideally. And so then they analyse, and then they write up their report. Usually it's in writing. I assume most listeners will be familiar with what mostly these reports look like, which is outlining the process that's been undertaken, setting out the evidence and making findings. And that's an interest. So they're making findings based on the allegations. So you heard me talk about allegations earlier. So it's important for them to be drafted well early on in the piece, because the whole investigation flows from those allegations. And so then, writing a report that's fit for the job, and the investigator may have been asked to just fact find, or they might have been asked to make findings about whether there's been a breach of a policy or a code, or the law firm might decide it's going to do that and not the investigator. Sometimes, very, very rarely, let's remember, the organisation doesn't have to accept everything that's put to them. Sometimes they ask investigators to make recommendations, but the organisation ultimately has all the information about, for example, if the respondent is a repeat offender and has a long disciplinary record, then they're going to take that into account around, where they land with disciplinary outcomes. So I think they're all the key elements, moving elements. It's obviously very complex. It's not for the faint-hearted to do this work. And what I would say is, you don't always have to go external to get someone to do an investigation. Let's not equate investigations with external investigators. Many organisations have in-house teams, including councils, where they have that expertise internally. And so they will choose then which cases they think are the ones that they should be doing internally. But obviously, if there's a conflict, such as it might be a complaint within the HR team, then that's the sort of complaint that would go external. So you want people who are experienced. If they're external, you might need to check that they're licensed. So lawyers don't need to be licensed. They get an automatic exemption regarding licensing, but other investigators do need to be licensed. And as I said, finding the right person for the task at hand is part of the decision-making process.
But I'm sort of hearing, and maybe I'm putting words in your mouth too, Sarah, but my sense is that if an in-house investigation is done, one wouldn't want to assume that just because someone holds a manager or coordinator role in an organisation that they're necessarily equipped to conduct an investigation.
Yeah, they would. You wouldn't want to put them in that position. And even just this short conversation, I hopefully has outlined that there's a lot of things that are required, usually for serious matters that are being looked into. So unless the person's got good experience. And you also probably have to work in a relatively large organisation to seem to be completely impartial. Yeah. And I know council environments are much more intimate in a sense, and it's hard to find people that have no knowledge or have had no contact with the set of issues. So that can be a challenge to councils, and often that might be why they do go external for investigators.
Yeah, that makes sense. Sarah, I wonder if we can talk about the dynamics around legal privilege and maybe broaden that out to confidentiality more generally.
Yeah, they're two very important points. And they're important because you don't always need to have lawyers involved in every single case. Let me just say that. I'm not here advocating for my profession. But sometimes the organisation, because they haven't done too much of that early analysis, jump into the investigation themselves and, retain an investigator and get a little bit underway, and they start to get some of the content of what this is all about, and they think, uh-oh, this is going to be, an S storm, and now we need to get the lawyers involved. Let's ring our lawyer, find out what we should be doing. And the problem with that is that the investigation has already started. And so it's going to be much harder then to apply legal professional privilege to that set of circumstances, because it wasn't instigated for the purpose of providing legal advice. So that can create a little bit of a sticky situation for a counsel. So they should think, in those early stages, do we need a law firm involved or not? And if they are involved, and if they then retain the investigator, then that's going to assure legal professional privileges in place. Now, the reason why it's in place is to enable organisations to seek and obtain legal advice and not to have to disclose that advice, in order for them to, do what they need to do to resolve or redress the situation. If that privilege, legal privilege, might be challenged or might be jeopardised if, for example, everyone's talking about what's going on, so confidentiality is not being respected, or if a report is provided and it's sent to all and sundry within the organisation, that then might challenge the legal privilege.
So just to be clear, Sarah, is what you are saying that just because there is legal privilege, there are a range of actions that might occur, even disseminating the report, that might undermine that and cause a loss of that privilege? That's
right. If the law firm's involved, which it normally is, or it might be the in-house counsel of the council that has, so the law officer that has retained the investigator and for the purpose of providing legal advice. But if all and sundry are talking about it, or if the report is disseminated, then it ceases to be a confidential document, and it ceases then to be covered by the privilege.
Right. So, yeah, you can't defend your privilege if you're, bandying the content around, basically. What about the more general kind of dynamics around the importance of confidentiality associated with an investigation?
So there's all sorts of sensible reasons for enforcing and communicating that confidentiality is critical. So the obvious ones are that if you've got they're always sensitive issues. If anyone's being accused of something, that's a sensitive situation that they find themselves in, and their concern, so the respondent's concern, is going to be that people are not all talking about these matters before they've been determined. The complainant as well, very sensitive issues, don't want everyone talking about it. And we know that when it leaks out, it can become quite a sort of divided workplace because of that, or a conflicted organisation, because everyone's taking sides about, who's right and who's wrong, and they all know the intimate details. So it's from the get-go, it's really important that, and as we know, policies really enforce this, that it's a confidential process. People just need to trust the organisation to follow due process in order to make the decisions that they need to make. And it protects everyone along the way from a reputational point of view. And we won't even touch on defamation. That's a topic for another day, but it's really important for that reason as well, to keep all these matters super confidential. The investigator will also be reinforcing that when they talk to people, and they will be saying, I would like to speak to you. I'm going to be gathering what you tell me. I'm going to be feeding it into my report and my findings. The organisation or the law firm are going to see my report. It is confidential. However, and this is really, really important, it is not a cast iron guarantee of confidentiality, and no investigator and no organisation should ever promise that something will remain confidential per se, because the information might reveal things that need to be acted upon, firstly, from a work health and safety point of view. So it can't remain confidential for that reason. So if someone's disclosing that they've been assaulted and then two other people say the same thing, but we don't want anyone to know about that, well, that can't be the case. The organisation needs to act on that information. Yep. The other reason why confidentiality is important is as I said, for legal professional privilege reasons, defamation is to be avoided. Defamation complaints are to be avoided in keeping things confidential. The other thing is that the report might be disclosed for the organisation to defend itself from litigation against a complaint, or where a regulator's investigating. So they want to know, did you organisation take all the proper steps? Please demonstrate those, and then the report might be provided to them to demonstrate that.
Yeah, that makes sense. So what would be, I guess, some common missteps, the top three, if you like, that organisation, or that you might see when organisations are involved in workplace investigations?
As I mentioned, potentially if a decision is made to get lawyers involved, making sure they get involved from the beginning, if that's the intention, and you may as well set it up with legal privilege. If the issues are important or to be kept confidential, or there are reputational issues, they're all warning bells that you want to involve legal professional privilege and lawyers. Another area I think where one can see missteps is just not providing sufficient support to all the parties involved in the investigation. So we get so focused on getting the process up and running, and sometimes there can be delays because people are sick, or someone's not available, they're on holidays, and it just adds all these reasons why individuals can't be spoken to. They might have been either stood down, or they might be on sick leave. And it's really, really important to keep keeping the people informed about what's going on along the way, so that they don't get stressed, because it is a very stressful process. Likewise, the stress around being interviewed, what does that involve? Am I the one being examined here? So good communication, putting supports in place. EAP obviously is one part of the support process. The other part is, particularly for respondents, I think, is nominating another manager within the organisation who can be a sort of a dedicated support person who's not involved in the facts of the situation, but can provide support to the manager. So that's something that I think taking a lot more care on how everyone's faring through a really difficult and challenging set of situations for them. And then I guess I think I touched on having good, well-drafted allegations, and then ultimately not having a predetermined outcome in mind. So particularly if you've got lawyers involved or external independent investigator they're dispassionate, they're looking at the issues, they're not caught up in the personalities of all these things, or the status of the individuals involved. And so organisations need to have a very open mind to let the process take its course, and not prejudge, and not make promises about what's going to come out of this, because you just never know. And you need to be open to the advice that you're getting from your advisors about what to do next. And sometimes you might be hoping that they're going to view the issues as really super serious like you see them, but they might not, take the same view. They might say this is not a dismissible offence, for example.
Yep.
It's a lesser set of issues. So then you have to work through, what do we do with that information?
And just know you can.
Yeah.
So a lot of caring about the people involved and slowing down, I'm hearing.
Yeah. And good Sarah? Process, just basically putting a good process a rigorous process in place that you can later defend the process and the decisions that flow from that process.
Yeah, I asked you about the things that might be missteps. Are there any other things that you would add to that in terms of steps to make sure that you get it right?
Look, ultimately, I think in particular, just someone who, in terms of decision about investigator, making sure that they are available to act promptly on the process, because, as I said, it's very stressful for everyone involved. It doesn't matter whether you're the respondent or a witness or a manager dealing with the set of, it's very disruptive for everybody. And so you want someone who can come in relatively promptly and, start with their process and conclude it within good time. I sometimes hear about investigations that have taken a year, and I can't get my head around that. And people are destroyed in that sort of a process. They might be a stood down respondent who is sitting there waiting to hear what's going on, and hard to recover from that.
Yeah, that is devastating. I guess just to round things out, Sarah, Stephen Covey in his 7 Habits talks about starting with the end in mind.
Yes.
What does And I don't know that we would ever talk about success, but what does a good investigation look like? What are the hallmarks?
Look, I think ultimately it's all the decisions are to go into transparency where one is able to be transparent, and that goes into touches on the good communications that should be built in all along the way and keeping people appraised of what's going on. When you give serious allegations to a respondent, for example, thinking really hard about the impact that that's going to have on them, so putting those supports in place for them. But ultimately, I think that the overriding principle that flows from having an impartial investigator is that there's a fair process and that everyone feels like they've been dealt with fairly. And that means, that the complainant and the respondent understand that someone has really carefully looked at the issues and independently assessed them, and that they feel that everything's been taken into account and that they've been treated fairly. I think that's the hallmark of a good process for those parties. And then I think just remembering that the human aspects of it right at the beginning of the process and at the end of the process. So whilst you might have a disciplinary outcome at the end, or if it involves counsellors, decisions that make some pretty tough calls about people having acted inappropriately, you still got to manage the relationships afterwards. So whilst everyone's a bit exhausted from the process and a lot of money's been spent on the process, there's not much more left in the kitty. But if I can urge people to really think about, well, actually we've still got probably people still having to work together and very raw, and relationships are a little bit, impacted by what's just happened. How do we now rebuild and get people working back together again, if possible? And sometimes that might not be possible. So then you've got to think about, all right, well, are there other options for individuals, and being open to those conversations?
Sarah, that human element, so I think a really appropriate place to land this topic. Once again, thank you so much for coming along today and bringing your expertise. This has been the governance update. Thanks to Hunt & Hunt Lawyers, and we'll see you again next week. Thanks, Sarah.
Thanks, Steve.